This is one of those cases where the courtroom tension is so thick you can almost feel it through the screen. Today, we're watching State of Georgia versus Cayman LaShawn Allen. And let me tell you, the stakes are sky high. Miss Allen was sentenced to 12 months probation for DUI and multiple violations, and she's back in court for her second hearing. The judge's patience, while it's wearing dangerously thin, for this isn't just about a missed appointment or two. We're talking 0 community service hours completed, no victim impact panel, no risk reduction program, and a $2,752 tab in arrears. And as we'll see, Miss Allen has explanations, but explanations don't always hold up in front of a judge who's heard it all. Buckle up, because this case is about to turn from mildly concerning to oh no, she didn't, very quickly.
All right, Ms. Allen.
Yes,
You're before the court on State of Georgia versus Kamikawan LaShawn Allen, 2021 CR 04498. Ms. Allen, you were before this court for driving under the influence, stop or yield sign violation on 25th day of September 2023, sentenced to 12 months on probation. You have 3 months and 21 days remaining, and this is your second hearing. You failed to report on April 14th, May 24th, June 4th for a revocation hearing. You were released from the hospital and instructed to report after being released. You last reported on January 22nd of 2024. You have completed 0 of 240 hours of community service. You failed to do a clinical evaluation. You failed to do a risk reduction. You failed to provide proof of a victim impact panel. You failed to provide proof of attending AA meetings, and your $2,752.50 in arrears. What's going on?
Let's pause here. Notice how the judge is running through a laundry list of missed requirements. This isn't accidental. Judges often do this to establish a complete record of violations before they even hear excuses. By listing everything, they close the door on arguments like I didn't know or I forgot. Here, we're seeing Miss Allen's probation violations stacked like dominoes. Missed reports, no proof of service, skipped evaluations, and yet, her attorney tries to soften it by mentioning some AA meetings and some community service. The key word, some. In court, some without proof is as good as none.
Your Honor, are you asking Ms. Allen to address it? So
whoever can explain to me why Ms. Allen's not doing what she's supposed to be doing.
So we were going to stipulate that there is a violation here in all these allegations of violation of probation. She has done some of the things, like I think Mr. Austin here, sorry, would agree with me that she has shown him some proof of some AA meetings. I think that was from February of this year going backwards. So there was some AA meetings. She maintains that she has done a significant portion of the community service hours, although Mr. Austin has informed me that she has not submitted proof, but he may correct me if I'm wrong, that he had some evidence that there was actually some community service being completed at a particular location.
That's great, but I never received the proof. And the young lady who she was doing community service no longer works there, Your Honor.
And other than that, she does admit that she didn't complete the clinical evaluation or the risk reduction program or complete the victim impact panel.
This is where the judge drops her first big warning shot. Why are you playing with me, Miss Allen? That's not courtroom fluff. When a judge says you're playing, it means they believe you're taking the court's orders lightly. And in probation violation hearings, that can be lethal to your defense. The judge is reminding Miss Allen and everyone listening that she already had a long conversation with her at sentencing. Translation: we've been here before. You knew the deal, and you still didn't follow through. Not a good sign.
Okay. Why are you playing with me, Miss Allen?
No,
I remember we had a very long discussion when I sentenced you. Very, very long. And this is your second hearing. We had a long discussion when you came up for the first hearing. Why are you playing with me?
I am not. I promise you, Your Honor, and I apologize if it comes across that way. What I can say is that I've learned over this year that I should not be relying on other people to relay me information, which is what has happened. I pretty much I've not had a stable place to live. My mailing address is my mother's. So I bounced between my mother, my father, ex-boyfriend, even a friend's house throughout this past months or 9 months or so. I apologize that I took other people's word for it as far as when I was supposed to report and when I was not, why I was supposed to report.
Now, Miss Allen starts to explain her unstable living situation, moving between relatives, an ex-boyfriend, and friends. She also admits she relied on others for probation, reporting information. Here's the thing. Courts aren't unsympathetic to hardship, but they expect self-responsibility. Relying on my mom told me is risky in a legal setting. If you're on probation, it's your job to know your dates, your requirements, and to follow through no matter where you're staying. And when you admit in open court that you saved certain programs for last just because you didn't feel like doing them, that's waving a red flag right in front of the judge.
And why it was not. And that's to make a very, very, very long story short, which is the reason why Ms. has half of the information to have proof of. There's no way these people could have seen me in this building all day, every day for 4 straight months and not attest to the fact that I was there doing my community service. Whether that lady was fired or not, she reports to somebody who reports to somebody, and I can give proof to you that I did it. The only 2 things I did not do is the last 2 that he said, the risk reduction and the drunk driving mothers thing. I just hate that. It's so disturbing. I honestly was saving it to last. But everything else I've been doing. AA meetings I do when I'm out. I do it just as a hobby. I love AA. So it's up to you.
What's the recommendation, Mr. Austin?
60 days to serve, ma'am. Credit from August the 9th. After the completion of the 60 days, case will be closed.
Nope. Ms. Allen?
Here's where the tension spikes. The probation officer recommends 60 days in jail, which is already a serious penalty. But remember, this is still up to the judge. The moment the recommendation is read, you can almost hear the mental gears turning. Is the judge going to be lenient, or is this the point where patience runs out entirely? Judges don't just consider the violation itself, they weigh attitude, prior chances given, and the likelihood the person will improve if given another shot. In Miss Allen's record so far, let's just say it's not screaming model probationer.
Why are you playing with me?
I'm not, I swear I'm not playing. The only thing I have done once again is relied on other people to give me my information, relying on my mother to tell me when my next probation meeting was. There's been times when I've tried to get in contact with him when I wasn't even supposed to report. Drove down here, we live in Decatur. Drove down here just off a whim saying it's been almost a month since the last time I see him. Let me go down here and see what's going on type of thing.
You working, Miss Allen?
No, ma'am, I'm not at the time. No, I'm not. I'm sorry, I'm not. I didn't have to be honest. Right before I started my probation with you, my husband and I got divorced. I think I shared this with you. We sold a house. I didn't have to work, honestly.
Oh, okay. Well, that's a beautiful thing. 3 months.
I have to now.
3 months.
This moment is absolutely crucial. The judge points out something that cuts right through all the excuses. If Miss Allen didn't have to work after her divorce, she had both time and money to finish these court-ordered programs. It's a subtle, but devastating point. She's essentially saying, you had the means. So the only reason you didn't comply is because you chose not to. And when you're trying to avoid jail time, the last thing you want is the judge concluding that your non-compliance was voluntary.
Because for somebody who didn't have to work, she could have afforded those classes. Those classes could have been done. For somebody who has a job, had a car, she could drive to her probation and get all that stuff done. You just told me you drove down here.
No, I said we drove. I
Who is we?
Me, my mother, or I don't drive, ma'am. My license are suspended.
I'm clear.
Yeah, I don't have a car or drive.
But you had money because you said you didn't have to work, but you could have done the rest of that stuff. And if you live in Decatur, they could have dropped you at a bus stop, or you could have taken the train, or you could have done something close to your house. Ma'am, let's.
The judge delivers a brutal assessment, calling Miss Allen an alcoholic. That's not just an insult, it's a finding with legal implications. By stating it outright, the judge is framing Miss Allen's violations as part of an ongoing substance abuse problem, not just carelessness. This matters because if the court sees you as a danger to yourself or others, they're far less likely to show leniency. And when she says, "I'm done playing," that's code for, "I'm moving to." The maximum allowable penalty.
Just be clear, because you know how I think. You're an alcoholic.
I know.
And I get that you know it, but when you don't do what I ask you to do, and this is the third time I am asking you to do it. First, when I sentenced you, probably sometime before that, when I talked to you about the charges that you had pending, because your charges pended for a minute. Then I sentenced you the first time, and I explained to you everything I wanted and everything I expected. Then you came up for another hearing, and I explained to you everything I wanted and everything I expected. You playing with me, and I'm done playing. So 3 months.
Yeah,
And Your Honor, would she be get credit for the time since she served since, I guess?
I'll give her credit since date of lockup, but she's gonna do 3 months.
Yes, Your Honor.
Now, Miss Allen, until you're serious about getting your life right, I don't have to be.
And
No, you telling me, well, see, I just gonna wait till the last thing because that's disturbing to me. What's disturbing to me is you out there drunk driving and then not doing the things that I asked you to do. The things that are important to me are the things that teach you something. The class, the impact panel, the community service. Those are the important things to.
The judge shifts into moral territory here, talking about what disturbs her spirit. This is important. Judges are human. They have emotional reactions to cases, especially those involving public safety like DUI. When Miss Allen admits she delayed required programs because they disturbed her, the judge flips it. What disturbs me is drunk drivers on the road. This reframing makes it clear. The court sees these programs as life-saving interventions, not just bureaucratic hoops.
Me. And you said you didn't have to work. You $2,700 in arrears, so you wasn't paying either.
No, that's not okay. So let me back up a little bit. I may have misspoke. I did a whole DUI probation 12-month period before I met with you. I completed it successfully. I had just completed all of that stuff in another county, Your Honor, in Cobb County. So it was fresh on my. I had just done, and it was, when I say it's disturbing, I didn't mean like it irritates me. I mean like it truly disturbed my spirit to go through.
Well, what truly disturbs my.
Listen closely. The judge says she wanted more for her but expected this. That's a dagger. It means the judge's initial hope has been replaced with disappointment. And in the judicial world, that often translates to a harsher sentence. The 3-month jail time isn't just punishment, it's a wake-up call. The judge is trying to force Miss Allen into a position where she must reflect on her life choices. This isn't about fines anymore. It's about a lifestyle overhaul.
Spirit is knowing that I got alcoholics out roaming the streets, driving cars and putting other people's lives in jeopardy. That's what truly disturbs my spirit. That right there. Oh, every day. It'll keep me up at night. So when I give you things to do that I think may make a difference in how you approach things when you get out of jail or when you finish this sentence, and those things aren't done, well, then my spirit is disturbed again. And I don't like for my spirit to be disturbed. I like to sleep. I like to spend the happy time once I am finished with my obligations to the court. But when I have to think about when your petition came up and I looked at it and I said, I wanted more for her, but I expected this. I shouldn't expect you to mess up. That's not how I go into this. When I sentence someone, my hope is that you will do what is necessary to get your life on track. Not just to pay your debt to society, but to make your life better. That is what I speak hope to people all the time. But you playing with me. And we're not going to do that. The 3 months, you think about what you're going to do when you get out. You think about how you're going to pursue your sobriety. You think about what you're going to do with your the rest of your life.
This is a courtroom mic drop. You got your hair braided, all nice and cute, but you're not paying your fines and fees. This is what I call the priorities argument. When a judge points out that you had money for personal luxuries, but not for legal obligations, it's devastating because it paints a picture of willful neglect. And in this case, it reinforces the narrative that Miss Allen didn't take her probation seriously.
Now, you got your hair braided all nice and cute. You had to pay somebody for that, but you're not paying for your fines and fees. You're not paying for these classes. Now you're about to explain how somebody did that for you just as a favor. No, ma'am.
I was,
Just let it go.
okay.
The final sentencing is laid out. 3 months in jail, with credit for time already served. The judge makes it clear, mess up again, and you'll be right back here. There's a certain finality in the way she says, do you want to come, see me again? And when Miss Allen answers no, ma'am, you can feel both resignation and maybe, just maybe, the first signs of reality setting in.
All right, so you'll serve these 3 months, and once you've served the 3 months with credit since the date of lockup, then this case will be closed. Miss Allen, you know above all things that if you mess up again, who you coming to see?
Come to see you, Your Honor.
Do you want to come see me again, Miss Allen?
No, ma'am.
All right, then. I didn't think so.
Judge, you were done with this.
Yeah, you can go back, Miss Allen. Thank you.
Thank you.
And there you have it. Miss Allen will serve 3 months for repeated probation violations, failure to complete mandatory programs, and unpaid fines. This case is a textbook example of how courts handle probation noncompliance, especially in DUI cases where public safety is at stake. The judge's message couldn't be clearer. If you're given a second chance, treat it like your last, because in this courtroom, playing with the judge's orders is a fast track to jail time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.